Alright, Chapter 16, Virginia Gas Oil Act. We're on 1601, Regulation of Coal Surface Mining not affected by this chapter. Nothing in this chapter should be construed with its limiting power of the director relating to the coal surface mining operation reclamation of the provision, Chapter 10, including requirements for the permits bounded with the shell with the apply with the gas oil with the geophysical operation located on any of the area with the coal surface mining permit is in effect and shall be in addition requirements of the gas oil with the geophysical operation set forth in this chapter, except for the well work with the operation with the pipeline on the area that has reclaimed claim. The surface line operated with the direct that shall be retrieved with the post mining uses. The director shall give the physical vessel consideration development of the adoption of variance of the proposed mining with the requirements of Chapter 10 for the gas and oil geophysical operations. However, all such variances shall be consistent with the provisions of Chapter 10. Alright, 1602, construction purposes. The provisions chapter shall be deliberately with the effect of effectuate the following purposes: foster the encourage, promote safety, efficient with the exploration, the development, production, utilization, conservation of the common gas oil resource. To provide method of the gas oil conservation, maximizing exploration, development, production, utilization of the gas oil resource. 3. Recognize, protect all the rights of the owner of the owning interest for the gas oil resource contained within the pool. 4. To ensure the safe recovery of the coal and other minerals. 5. To maximize production and recovery of the coal without substantially affecting the right of the gas oil owner proposed to drill gas oil well explored with the producing gas oil. 6. To protect the citizens and environment with the commonwealth of the public safety and environmental risks associated with the development of production gas or oil. 7. To recognize the service of the gas oil development should only be with the reasonable and necessary to obtain gas or oil. Alright, 1603, Virginia Gas Oil Board Membership Compensation. Virginia Gas Oil Board with the established policy board with the executive branch of the state government for the purpose of the board is to carry out the provisions of the chapter. Be the board shall have the total membership of the 7 of the members consisting of 6 non-legislative citizen members with the 1 ex officio member. Non-legislative citizen membership of the board shall be appointed by the government with the confirmation from the General Assembly, filed with 1 of the representatives of the gas and oil industry, not the coal industry, 1 representative of the coal industry and not the gas oil industry, and 4 who are not represented with the gas, oil, and coal industry, with the directors of the designee shall serve with the ex officio with the voting privileges. The chairman shall be designated with the governor among the membership of the board. See all vacancies occurring on the board should be filled with the same name of the original appointment within 60 days of the occurrence of the vacancy. Ex officio members of the board shall serve with the term coincident with such of the members of the term of the office of the appointment filled with the vacancy with the other expiration of the term shall be there for unexpired term after the initial instaggerization term of the non-legislated citizen members shall be appointed for the term of 6 years from the date of which the term of the immediate predecessor expired. All members may be appointed. Non-legislative citizen members of the board shall be citizens of the Commonwealth. The governor shall seek to appoint the person who reside in the localities with significant oil, gas production, storage. D. Each member of the board shall receive the compensation performance for his duties provided in 2.22813. All members shall be reimbursed for responsible the necessary expense for the incurred for the performance of the duties in Statute 2.22813 and 2285. Furthering, the cost of the compensation expense for the members shall be provided by the department. Alright, 1604. Duties of the responsible the Director of Virginia Gas Oil Inspector. Or the Director of the Jurisdiction Authority necessary to enforce the provision of chapter. The Director have the power of the duty to regulate the gas oil geophysical operation, collect the fees, permit other responsible to prescribe in the regulation adopted with the Department of the Board. B. The Director shall appoint with the Virginia Gas Oil Inspector. Alright, exclusive 1605. Exclusivity of regulation and enforcement. No locality, other public self-division with the Commonwealth shall impose any of the condition require any of the local license, the permit fee, with the bond that varies in additional requirements for the chapter to perform any gas, oil, geophysical operation. However, no provision of the chapter shall be construed limit supersede with the jurisdiction of the requirements set by the agency local land use ordinance regulation with the general purpose pursuant to 58.1, 37.12. 3713, 3713.3, 3713.4, 3741, 3742, and 3743. 1606 Confidentiality. The director shall hold confidentially all of the log surveys report dealing with the drilling, completion with the testing of the well, with the file with the gas oil operator in the chapter period of the 90 days after the completion of the well, or 18 months after the total depth of the well has reached, unless however the occurs first upon receipt with the gas and oil with the geophysical operation written request. Director shall have confidential such information concerning the exploratory of the well for the core hole for the period of the 2 years for the completion of the well for the 4 years for the date such as well hole reaches total depth whichever occurs first. The director of the good cause shown by the gas or oil geophysical operator may annually extend the period of time of the information regarding exploratory drilling is held with confidential. However, the director shall, upon request, provide a copy of any survey log with job through the local coal seam to the coal owner. 1607 Expenditure of the funds. All funds except for the civil penalties collected pursuant with the SU 45.2 1608 collected appropriately with the department pursuant with the provision of the tax are expended only on the purpose of carrying out the provision of the chapter. Alright, 1608 Violation penalties. Any person who violates, or refuse, or fail with the neglects to comply with the regulation or with the board direct for the inspect for the condition of the permit, the provisions of the chapter for the guilty of the class 1 misdemeanor. Being in addition to any person who violates with the regulation or with the board of directive for the inspect for the condition of the permit, the provision of chapter shall, with upon with the finding of the appropriate circuit, could be assessed with a civil penalty not more than $10,000 for each for the day with such violation. All of the civil penalties in section shall be recovered by the civil action brought by the General Attorney General in the name of the Commonwealth. Of the court shall direct for the civil penalties assessed for the section shall be paid with the Treasury of the county or city where the gas oil geophysical operation determined by the court is violation is located. See if the board with the consent of the gas oil geophysical operator may provide an order to issue for the board and against such operation payment that civil penalties past violations specific sums not exceeding the limit specified in subsection B. Such civil penalties should be instead of any of the appropriate civil penalty that could be imposed under the section do not be subject to provision 2.2, statute 2.2, 514. Civil penalties collected under this section should be paid into the treasury of the county or city where the gas, oil, geophysical operation subject the order has issued to the board is located. 1609 Appeals and Venues. Any order decision of the board may be appealed for the appropriate circuit court with the coal owner, coal operative of the gas owner, with the gas operative of the operative of the gas storage field, with the certified by the state. The Corporation Commission is a party of such action when the court shall hear such appeal with the de novo. The court has the power to enter the interlocutory orders as necessary to protect the rights of the all interested party with the pending of the final decision. B. Unless otherwise agree, the venue of the court review shall be the county or city where the gas oil with the geophysical operation subject to such wherever the decision is located. See the director all of the parties required with the given the notice hearing with the board pursuant to the provisions 45.2, 16.18 when they have the standing with appeal with the order of the decision board shall directly affect them the permit with the permittee application director and those of the parties standing on the object pursuant to the provision for statute 45.2, 1632 shall have the standing of the appeal with any order decision of the board with the direction effect for them, however, the acceptance of the agreed permit application with the director. No person shall put the standing appeal with the decision board concerning with the permit application unless such provisions such a person has previously filed with the objection with the director pursuant to the provision of statute 45.2 1637. Filing any of the petition appealing with the concern with the issue of the new permit object with the pursuant with the provisions of statute 45.2 1611 and 1612. By gas storage field operator, we will assert for the proposed well work with adversely effect with the operation of the gas storage field certified by the State Corporation Commission shall automatically stay with the permit until the such state is dissolved over the appeal with the decide with the circuit court. However, if an appeal with the gas storage field operator of such automatic stay shall not apply with the oil, gas, coal bed, methane, well completed more than 100 feet above the cap of the rock above the storage stratum. 1610 Copy of the lease to the lesser. Copy of the lease to the leaser. Any person, either principal agent, execute the lease of the land of the right to drill and gas oil for the development of production gas shall furnish a copy of the lease duly executed by the lease to the lesser. Leaser to the lesser. Part 1611, objections to coal owners. The decided for the objection of the coal owners proposed the permit modification of the drilling unit modification. Only the following questions are considered. One, whether the work can be done safely with respect for the person engaged with the coal mining over the near the well site. And two, whether the well work is unreasonable, arbitrary action of the well operated with the right to explore with the ore and market and produce gas and oil. B, in inducing and deciding objection for the coal owner establishing with the drilling unit issue with the permit of the new well with the stipulation of the coal bed methane gas well. Following safety aspects shall be first considered with no order for the permit shall be issued with the evidence indicate that the proposed activity unsafe. One, whether drilling unit or drilling locations above or the close proximity to any mine with the opening and shaft of entry, travel way, airway, haulage way, drainage way, passageway, or to any proposed extension thereof of any operated abandoned operating coal mine, any of the coal mine area already surveyed and plotted not yet being operated. Two, whether the proposed drilling can be reasonably done with the existing planned piler of coal or in a closer approximately existing well with such of the piler of coal the total of the consideration for the topology. Three, whether the proposing well can be drilled safely. Proposed coal bed methane will give the simulated safety taking into consideration dangerous creeps, squeezes, or the distribution due to the extraction of the coal. And four, the extent of the proposed drilling unit with the drilling location stipulation coal methane gas as well as unreasonably interferes safe recovery of the coal, gas, and oil. C, following questions with respect to the drilling unit, drilling location, new well stipulation, new coal bed methane gas shall be also considered. One, the extent to which proposed drilling location, coal methane gas stipulation will unreasonably interfere with the present future coal mining operations. Feasible. Two, the feasible moving proposed drilling unit, drilling location, mined out area below the coal outcrop, some of the other areas. Four, three, the feasible drilling moratorium for no more than 2 years in order to permit completion of the coal mining operation. Four, the method proposed for the recovery coal gas. Five, the practicality locating unit well uniform pattern with other units and wells. Six, the strip of the topographic in use. Similar whether the decision substantially fit for the right of the gas owner operator to explore and produce gas. D, the factors in subsection C are not intended shall not constitute an authorized directive of the board under Section 45.21638 supersede, impair, and abridge any other contractual rights or obligations existing between the respective owners in coal, gas, any interesting in therein. That was 1611. Alright, 1612, distance limitation certain wells. If the well operator objects and the coal operator who are present for the representative of the hearing consider the objection of the proposed drilling unit location unable to agree upon with the drilling unit location from a new well within 25 linear feet of the location existing well of the well which of the permit application is on file within the permit when the drilling unit shall be refused. B, the distance limitation established by the section shall not apply with the one if the proposed well will be drilled through any existing plan piler of coal required for the protection of the pre-existing well drilled within any depth and two of the proposed well, neither requiring an enlargement of the piler nor otherwise adversely affect the existing planned coal mining operations. We're going to cut the tag. That was part Article 1, General Provisions of this chapter's Code, Title 221, Code of Virginia, Title 45, 2, Minerals, Mines, Minerals, and Energy, Chapter 16, Virginia Gas and Oil, Article 1, General Provisions.